Good afternoon and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Tulo Hoyane. This afternoon, I want to bring you a shock development in the MEYIWA trial. Something totally unprecedented in the history of criminal trials in South Africa. Something that never happens and is being seen for the first time in the MEYIWA trial happen. And unfortunately, everybody there is going along with it. From the judge to the prosecution and the defense, because it is in fact the defense that has embarked on that strategy. Let me unbundle what is happening. Let me unbundle what is happening in the MEYIWA trial for you, just to give you a sense of what I'm talking about. After Advocate Mnisi had led Moses Sibiya, the first accused in chief, the first defense witness to enter the witness box, that was Moses Sibiya. After he had concluded his evidence in chief, what then ought to have followed was cross-examination by the prosecution. Advocate Baloyi should then have proceeded with the cross-examination of Moses Sibiya. That did not happen. For some strange reason, it did not happen. We saw Advocate Ramusipili and now Advocate Ngumalo first to take the stand in what was called cross-examination, first by Attorney Ramusipili, who was then followed by Advocate Ngumalo, was then allowed by the court. That is an irregular step that will forever render this case a legal circus. A legal circus. And let me tell you why it is going to be a legal circus. The defense team, let me begin this way. Moses Sibiya is part of the defense. He's one of the accused persons. In fact, he's the first accused person in the MEYIWA trial. So he belongs in the defense camp. Now, after he has tendered his evidence in chief as led by Advocate Mnisi, how then do other defense counsels cross-examine him? And what is cross-examination? Cross-examination is an exercise in law that is embarked upon by one side to discredit, and I want to underline that word, to discredit, the version put forward by the other side. In other words, the objective of cross-examination is to discredit the version given by the other side and to destroy it and to attack it. That is what cross-examination entails in law, not what we are seeing unfold before the Pretoria High Court as I speak to you at this moment. Now, Attorney Ramusipili and Advocate Ngumalo both belong to the defense in a case in which their respective clients or accused persons are charged with a common purpose, in that they conspired to kill the late Senzo MEYIWA. So how does another colleague in the defense, a colleague of Mnisi, because these are Mnisi's colleagues in the defense team, how do members of the defense team namely Attorney Ramusipili and Advocate Ngumalo, then stand up to purport to cross-examine Moses Sibiya, right? Who is represented by Advocate Munisi, who is also part of the defense. And how does it proceed? It is called cross-examination. What they do is called cross-examination, but it's not cross-examination. In fact, it becomes a purposeless, right? Directionless. And whatever outcome it is going to yield will add no value at all to those proceedings. Because this cross-examination by the two defense counsels of an accused person is not cross-examination because it is not intended to attack and to discredit the version put by Moses Sibiya. They are not doing that. And if they are not doing that, whatever it is they are involved in cannot by any stretch of imagination be characterized as cross-examination, such that they get an opportunity to stand up and embark on it, purportedly because it is a procedural way of doing things, and it is termed cross-examination. And it was not cross-examination. In effect, what it was a sort of, again leading Moses Sibiya in chief, or alternatively to get Moses Sibiya to deny some of the things that they wanted him to deny regarding, whether the accused persons knew each other, or regarding the evidence that had been tendered by people like Constable Zungu. For instance, Moses Sibiya has denied ever meeting Constable Zungu at the Basotho hostel, where Constable Zungu testified that he overheard a conversation among the accused persons shortly after Senzo MEYIWA was shot and killed. You'll recall that Zungu says he overheard a conversation among the accused relating to the killing of Senzo MEYIWA. So this exercise to try and elicit Moses Sibiya to say or to deny some of the things put forward by the likes of Constable Zungu, is a futile exercise, because it is actually getting the accused persons who are charged with one crime and who have similar interests. And not only are they charged with one crime, but they are charged with the doctrine of common purpose, the act of one being the act of the other. It does not achieve a thing, because this is simply accused persons corroborating each other in an exercise termed cross-examination. And it is not cross-examination, and can be disqualified or expunged from the record, because it does not follow the tenets of cross-examination. It does not fall within the four parameters of what constitutes cross-examination. So what is likely to happen to, evidence, elicited under those circumstances? Unfortunately, Judge Ratamukwatan doesn't see this. At some stage, the prosecution put up, a lame duck objection through Baloyi, who said that Attorney Ramusipili was sort of, trying to lead him in chief again. But the court has let it all go. So what we are seeing unfold before the Pretoria High Court now, we don't know whether after Advocate Ngumalo, the lady advocate, how do I forget the only lady advocate in that trial? Right? But anyway, the advocate representing accused number 5, right? We don't know whether she will embark on, the same strategy of telling the court that she also wants to cross-examine Muzi Sibia. So this is the unfortunate development that I am seeing unfold in the Pretoria High Court. It is an unprocedural step and it amounts to nothing. It will not enhance in any manner the defense of the accused persons. And any other court that will be seized with this matter in the future will condemn this process for what it is: a waste of time and unprecedented development. The lady advocate is Advocate Mshololo. We don't know whether Advocate Mshololo will be embarking on the same process, thus dragging the trial further and further. And this time, it does not even advance the interests of anybody. Does not advance the interests of the defense, does not advance the interests of the prosecution. It is a wasteful procedure. It is a wasteful, irregular procedure that should not have been embarked upon. Due regard being had to the, to the fact that what is cross-examination and what is the objective of cross-examination? What we are seeing unfold is not cross-examination. Whatever it is, I don't know what it is. But they better give it another name because it is not cross-examination. But having said that, I will bring you in a later edition of the Daily Fix another angle and analysis of what I frankly, with all due respect to that honorable court, with all due respect to the prosecutors and the defense lawyers, a charade, and it just brings the whole system of the whole criminal justice system into disrepute. Having said that, let me thank you for watching this video. Let me thank you for all the views and subscriptions that I'm seeing. The 12,000 subscriber mark is here and a click away. Please kindly subscribe so that we can bring you this insightful news and analysis twice on a daily basis. Thank you very much and enjoy the rest of the day.